It is now time to discuss a landmark judgment regarding the ESI Act. Hopefully, this will help you better understand the inner working of the ESI and the ESI Corporation, which carries out the insurance scheme. The case will highlight how the ESI Act takes measures to prevent employees from taking undue or double benefit from insurance through any other insurance act, so long as they are covered under the ESI Act. The case is Mr. A. Tehan versus Messrs. Associated Electrical Agencies and another. In this case, the plaintiff, Mr. A. Tehan, was under the employment of one of the defendants for carrying out television repairs. On July 17, 1987, he was injured during the course of employment while repairing a television set when a component burst and he suffered injuries on his face. After claiming relief from the ESI Corporation under Section 46 of the Act, he then filed an appeal asking for compensation under the Workmen's Compensation Act, which requires an amount paid by the defendant. This was challenged by the defendant in the Bombay High Court via an appeal, which contested their payment of the compensation and called into usage Sections 38 and 46 of the ESI Act, which lay the foundation for the insurance offered by the Act. Section 38 guarantees that every worker is insured under the Act, and Section 46 defines the relief available to workers. This was further verified by the High Court, whose division bench further stated that the worker's appeal for the amount to be paid by the plaintiff could not be upheld, as according to the provisions under the ESI Act, he would receive compensation only from the ESI Corporation. Once he receives that said compensation, he cannot claim benefits from any other compensatory act. Instead, he would receive appropriate relief to be determined by the ESI Corporation.